Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. Attorney Thomas D. Begley III is a certified elder law attorney with over 30 years of experience helping families navigate estate planning, trust administration, Medicaid planning, and elder law with confidence and care. I'm LeAnn Lyon, and today we are digging into how to handle real estate in your estate plan, especially when more than one person may want a piece of it. Hi, Tom.
Hey, LeAnn.
Tom, why is real estate often the trickiest part of an estate plan, especially when it comes to vacation homes or sentimental property?
So real estate is quite dicey for a couple reasons. One, the idea is somebody in the family may want, mom and dad's home when mom and dad leave the earth. And the second, which is a real big one, is dealing with the shore homes, which is a problem which is relatively unique to, states that, have on the various East Coast and the West Coast. But in New Jersey in particular, a lot of people have summer homes down at the shore, and they want to make sure that they pass from generation to generation. The problem that it's often easier said than done.
Yeah, I've been to the Jersey Shore. It's beautiful. It's amazing. I can imagine why people want to keep that in family. So what happens if multiple children inherit a home together, but they don't agree on what to do with it?
What happens, unfortunately, there is that there's a concept called partition. And partition basically, I'll just give you a great example. Mom and dad had 3 children, and they wanted them to have the shore home. And despite advice to the contrary, they transfer the property into the names of all 3 children. So what occurred was, after mom and dad were gone, everything was okay for a couple of years. But then there was a relatively significant repair that needed to be made to the home. And the middle child wanted to fix it, but probably make it a little extra nice, which makes a little bit of sense because it's the shore. You probably won't have the ability if you're going to run it to make it a little more attractive than the average home. The problem was his older brother was 62 and he was going to retire in a couple of years, and he was moving to North Carolina, so he wasn't going to be using the shore property anymore. So he wanted to put a Band-Aid on it, for lack of a better term. And then the big problem, and this is why this by the way, this is the last time I ever did one of these deeds, was the youngest child. He was a nice enough guy. He loved going down to the shore, but he didn't have 2 nickels to rub together. So he didn't have the ability or the desire to fix it. So we had 3 brothers arguing about how things were going to be managed as far as the expenditures in the home. And, the next thing that happened was there was a lawsuit called a partition action. It basically means you're dividing it, obviously you're not taking out a huge saw and dividing the house in 3. The upshot is that when the partition application is granted, and it always is, that there's a for sale. It used to be some counties still is, where they have the sheriff sell it, and you're lucky if you get 60, 70 cents on the dollar. So it really is a reason not to consider doing these things lightly, or at the very least they require that a realtor be assigned to list it for sale. But once again, it's still a sale that's under stress, so everybody loses. So, but there's ways to plan, but you have to make sure that mom and dad just don't leave the house. I often recommend that they take, certain alternatives before they decide to leave the house to the next generation.
So how can families avoid future conflict when it comes to shared property or generational real estate?
Well, there's 2 ways to do that. The first is, let's make a decision as to whether individuals are going to all want to be down there. A lot of times when mom and dad are alive, the children will go down on the weekends or, once a month or wherever they're in town. But a lot of times you'll find out one child may use it more than the others. So when you think that's going to be the case, you can set it up where you offer what's known as a right of first refusal. And basically, I had one recently I did. Mom and dad had about $4 million, $1.8 million is the value of their shore home. And one of the 2 children seems to be really interested in buying the shore home. So what's going to happen is that when mom and dad die, she doesn't automatically get the home, but she's allowed to say, hey, to her sister, she can say, I want the house, and as my part of my share. So this is oversimplifying a little bit. What would happen is, let's assume mom and dad left the earth and the values are about the same. Basically, she'll get the house that's worth $1.8 million and she'll get $200,000 in other assets. And then her sister will get $2 million. Okay, that way, that is a good way to plan because they're not fighting over, what to do with the house. And if the person doesn't want to exercise the right, then the property just merely gets sold. Now, the other is if you're going to have the property given to the children to try to make this work, what I've always recommended is that the property be put into a trust rather than given outright. And that's done for a couple of reasons. Well, three. One is management, and second is intergenerational planning. Um, and the third is for what I call liability or bloodline purposes. So let's say mom and dad pass on, they've got the $3 million house in Ocean City that they want to leave to the four kids. So each of the four kids has $750,000 each in equity in the home. So uh, first, I think I've already talked you out of putting everything in, or anybody out of putting the names of just the four children. But if you set it up in a trust of which the four children are the beneficiaries, then first, if you're going to do it correctly, you do need to make a system where you're going to say who's responsible and how are these going to be paid. Sometimes, depending on financial circumstances, we'll set it up where not only is the children are going to get the house and be beneficiaries under this trust, but we'll set aside a little bit of cash from mom and dad's estate to pay for some ongoing repairs. That way, if people have different, financial, backgrounds, it's not a strain or, on one particular person to keep up their share. The other is for the issue of protection. Sometimes you may have a case where we have four children, but one of them has problems with creditors, and the next thing you know, they've got judgments against them. And when it's time to sell the home, before the net proceeds are distributed, the creditors get paid. The other is that you have a case where somebody's getting divorced, and there's a divorce. Then you don't want to have somebody's son-in-law or daughter-in-law being a part of this particular uh, property. So we can do what's called a bloodline trust, whereby it's one of the rare areas of the law where you can have your cake and eat it too. I mean, the children can be the trustees of their own parts of the bloodline trust that own the property. But if there's ever a divorce or something bad that happens, the property is protected, and not just their interest, but the interests of their siblings. And the other thing which is really nice is even if you have the best in-laws in the world, most people tend to like their grandchildren more than they like their son-in-law or daughter-in-law. It generally can be set up where it can go to the next generation. Now, that comes to the third thing. Some people are okay with being partners with their brothers and sisters, but they're not necessarily excited to be partners with their nieces and nephews. But on the other hand, we need to make sure that that's economically fair. So there's a fair amount of counseling that's done to make sure this works out correctly. So a lot of times, if we do think everyone's going to get along fine, that's great. However, we do believe that there may be some intergenerational discord. Then it's set up that, let's say, I'm one of four siblings that has an interest in the house, and uh, one of my brothers or sisters passes on, and basically what would happen is I'm not going to be a partnership with their kids. What I'll do is the remaining shareholders, for lack of a better term, have to buy that individual out. And if they don't buy that out, then the person does, or those children do maintain the interest. So what I'm getting about sounds a little extra complicated, but we're talking about very expensive assets. And I tell people from tongue in cheek from time to time is that I don't get paid to do documents. And that is true because you can put something down in paper, but if it's like, the simple, I call the kumbaya, plan where you're saying, I'm going to get the house to the four kids down at the shore and they'll hold hands and sing kumbaya and everything will work out dandy. That's not realistic. I mean, really what's going to make a trust or any sort of plan involving a house work is to sit down and be realistic and think about the things that naturally are going to happen or could realistically happen and make sure that those are addressed in the document in black and white writing, as they say.
So, how do capital gains and tax consequences come into play when heirs sell inherited real estate?
Let's assume mom and dad have passed away and the property is left to the children. That's the easiest one to answer because there's the issue of what's called uh, basis for capital gains, and that applies to real estate uh, and also to and stock and also businesses. So let's go to real estate because that's what we're talking about today. So if I bought a house um, years ago for $300,000, and when I pass away, it's worth $1 million. What happens is my cost basis of $300,000 gets stepped up to $1 million. So if my kids turn around, I got five of them, they sell the property, right after I die, there's probably no capital gains. Now, this is important to note because sometimes people want to give the property away during their lifetime. Now, if they just give the property away to their children during a lifetime, that $300,000 base I have gets carried over to them. It doesn't matter whether they sell the property while they're alive or I'm gone. Their base is 300,000. They sell it for $1 million. They have a $700,000 gain. Now, picking up on what you said, let's assume they decide they want to keep the property. Their basis will be $1 million. And this would go into the issue of how you structure any sort of agreement or trust, because ideally you would want to have it set up where years from now, with the children pass on, but maybe we get some sort of additional step up, and that's you have to somewhat do a little bit of balance because if you do the bloodline trust, there's protection for divorcing spouses and creditors, etc. On the other hand, the cost basis is typically fixed at what the date of death value was for mom or dad. On the other hand, you can certainly set it up where and I've had a family do this where they set up as an LLC. And so and they all are individual owners. Now, if there's any discord in the family, there may be some exposure as far as the asset. On the other hand, when each of them passes away, you know, their share will get stepped up to their date of death value.
So, what if the property has a mortgage or unpaid taxes? How does that affect distribution?
As far as unpaid taxes in the mortgage, generally those they survive the decedent. So if mom passes away and she's got a house, and whether it's the shore or anywhere else in the state, and there's some unpaid taxes and unpaid mortgage, well, generally that's going to get accelerated. If people do try to inherit the house and the mortgage has been paid on a timely basis, more often than not, the mortgage company, as long as you're making the monthly payments, isn't going to enforce the due on sale clause. But it's not ideal to have an estate be the owner of a property for an extended period of time. So generally, and what the law mandates is that the first obligations of the estate are the payment of the funeral. The second is, administrative costs such as executor fees, accounting, and attorney fees. But the first debt that has to get paid are the taxes and the mortgage. So if there's any liquid assets, these have to be used to pay for the property prior to the property being given to somebody else in the family.
Well, let's say somebody wants to make sure that their spouse can live in the home for life, but still passes it to the kids later. What's the legal tool for that?
Hopefully, if you're married for the first time, you leave the property, you own the property together, or if you did buy it before you got married, that you leave it to your husband or wife. But what you're bringing up, LeAnn, happens more and more with people that have children from prior marriages because their second, third marriage. So, and actually, I had one that I just got retained this morning to do. Basically, it's a husband and wife, very nice couple. They've been married for 15 years now. They each have one son, and they want to make sure that if something happens, that the property is going to be equitably divided between the two families. So they have a deed that has both of their names on it. But the way that works is what's called a tenancy in the entire. It's like a right of survivorship for married people. One dies, it automatically moves to the other. So the first thing we're doing is changing the deed to create what's called a tenancy in common. And the tenancy in common basically says that when the husband dies, his half goes to his estate rather than to the wife, and when she dies, it goes to her estate rather than to the husband. And to make sure we take care of that surviving spouse, though, we provide them with a life estate. So let's say, for example, I'm on, marriage number two, And that's never going to happen. My wife's a nurse; she can kill me in my sleep without leaving a trace. But let's say hypothetically that did occur, and basically, my wife, I would leave her the right to use my half of the property until the day she died, um, or with some other conditions, which I will make. For example, if she can no longer afford the carrying cost, we would end the life estate then and compel a sale. Or if she ever went to a nursing home for a permanent basis, there's some other things you can do with just the pure life estate. But then once the life estate is terminated, whether it's death or one of these other reasons, the property would get sold, and my half is going to go to my family, her half is going to go to her family. So in this particular case, the way it's set up is that we're putting the deed in a tenancy in common. When one person dies, the other person has the right to use it. But when both of them die, what's going to happen is, her half is going to go to her son and his half is going to go to his son. And that's not the most complicated thing in the world to do. It's a pretty straightforward thing that you can plan.
Excellent. Well, as we wrap up today's episode, what is your advice for someone who's emotionally attached to a property but unsure how to pass it down responsibly?
First and foremost, get good advice. I know that sounds very cheesy, but just saying go get a good will or get a good deed, that in and of itself doesn't do it. As I think I've indicated throughout the course of this episode, if you're going to leave property behind to one or more of your children, you have to first ask yourself whether it's realistic. And that's when you need to get the advice of someone who's experienced in dealing with this on a day-to-day basis. And this is where I tell people I provide the most value. And it's not really selling myself, but because I see it all the time, I've had people come in, and after we discuss whether it's realistic or not, based on their personal background, sometimes we still go ahead, but we go ahead with a plan that's going to work and make sure that the kids are taken care of, and that the house does stay in the family. But oftentimes we've had the case where after, despite the emotional attachment, when they come and discuss things, they decide to either, abandon the plan or modify the plan. Some people say, this is just never going to work. And it's better to have that sober decision now than have the kids get a house and tear each other apart in court and spend tens of thousands of dollars to fix a plan that could have been really nice to begin with.
Excellent. Excellent advice. Thank you. And to our audience, thank you for listening to The Estate Blueprint. Whether it's your home, a shore house, or land that's been in your family forever, smart planning can protect the memories and prevent the mess. To get help from Tom Begley's team, visit Begley3law.com. And remember to like, subscribe, or leave a review if you enjoyed today's episode. Thank you, Tom.
Thank you, LeAnn. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.